Finish your thought, Mr. Haas.
Thank you. The bankruptcy court, in dismissing the second time, actually encouraged, and that's the words of the court, quote, strongly encouraged, and, quote, urge us to continue the process, to go forward with the bankruptcy negotiations, and to go back into bankruptcy to get it done. And why? Because the claimants supported the plan. So even though the bankruptcy court recognized that under the Third Circuit's novel new standard, which is different than every other circuit court in the country, the bankruptcy court said, nonetheless, you should go forward and do it because it's in the best interest of all claimants. And in the end, that is the key. Because if you're in the tort system, most of the claimants would receive zero, and it would take 3,000 years to have adjudicated the cases that had been filed at the time of the bankruptcy, let alone the additional thousands that had been added thereafter. So the only way to get an equitable, efficient resolution was through this process. And you asked, why would we spend $8.9 billion? Litigation expenses. There are hundreds and millions of dollars being spent litigating meritless claims year after year after year after year. And yes, there was a desire to put a stop to that. And the way to put a stop to that was in the best interest of all parties, two claimants, was the proposed resolution they made.
Thank you. Mr. Hessler, mass tort litigation, are you familiar with that at all? Yes. Okay. You need to put your mic on. So if you have a situation where a lot of people have been allegedly hurt, mass tort litigation allows sort of the consolidation of the claims, right?
Yes, Senator.
Okay, and that's to get things moving quicker. You form a class, people enter into the class, and you can litigate for the entire class. The goal of that is to do what?
Get to a consensual resolution as quickly as possible.
Bankruptcy, in terms of settling outstanding litigation, has its own system. Is that correct?
It does have its own set of federal bankruptcy rules. They're notionally consistent with the federal rules of civil procedure, but they actually move faster.
But the goal of this is to have claimants come in, resolve the matter, bring closure in a more expedited fashion than general litigation. Professor Pahik, in the Johnson & Johnson case, did the system work in your view?
Did the system work in Johnson & Johnson? Well, the case was dismissed. We didn't necessarily get a chance to see that settlement be realized. So that's why I mentioned earlier this idea of going back to this objective, getting meritorious claimants the recovery they deserve on the shortest timeline. The thinking was that would have been possible if this settlement would have been allowed to move forward.
Okay, so in terms of how to settle these claims, do you think bankruptcy, what changes would you recommend we make to the bankruptcy system?
I outlined some of those in my oral statement. I think making one section of the code applicable to all mass tort cases, that would be very valuable. The idea of improving the integrity of the system when we think about who's representing future claimants. Of course, these victims are not in the room. Someone has to represent their interests. The process of appointing that person has to be addressed to address due process concerns. And then also this idea of having the tools, as Professor Jacoby mentioned, right? So in bankruptcy, we have these power tools. Sometimes they are essential to reaching resolution, one of which is the third-party releases. These releases, under very limited circumstances, can be extremely valuable.
Well, you're trying to encourage people to put money into the system, but what they get in return is finality, right?
Exactly.
Yeah.
Exactly. And the idea is that could improve victim recovery.
I mean, trying to get claimants a pot of money people can apply for in real time. Well, fascinating discussion. One thing I would say to the committee is that there are different ways to resolve litigation, mass tort litigation, major claims against big companies. In social media, there is no model like this. So we may not agree on how to resolve this issue, But if you're harmed by social media, you have nothing. Zero, zip. That's where I hope the committee can come together and create rights of actions to the millions of Americans who are being abused without any opportunity to have their day in any court or any system.